All right, and then let me see here. Camera, a web camera set up. All right, and then I'm waiting for some setting to take place. Yeah, there we go. All right, just going to get my other things set up. So let me introduce myself. My name is Mr. Max Chaudhary from Chaudhary Law Office, and I've been a lawyer for about 30 years in the immigration law field, and I have these webinars periodically every third Thursday of the month, usually. And it's just meant to showcase and try to give context to the various types of news that come out and try to give some general guidance for people who may have questions arising from their, for example, web searches or looking up immigration fora or talking to a friend who applied for some kind of visa application, leading to them maybe to get some clarity about what they may have heard about a particular immigration policy. And inevitably, some people will simply ask a question about their own personal circumstance. That's fine. Keep in mind that this would not be considered as legal advice because it's impossible to get the proper context and background circumstances of a person who may be actually seeking legal advice. But this can still serve, nevertheless, to provide at least some direction to the immigration query you may have. And this could encompass Canadian citizenship or Canadian immigration or refugee law or the subcategories of immigration, such as express entry or humanitarian compassionate, or the more exotic types of applications like temporary resident permits, which are used for certain admissibilities. And also the kind of obverse for immigration lawyers, which is questions related to removal from Canada, or sort of a hybrid as well, which is people who may have had a bad history with immigration to Canada, and now they want to maybe give Canada some kind of second shot or opportunity by trying to maybe visit or settle in Canada despite having a negative interaction with the immigration authorities. With that in mind, please, what I encourage is, please, I'll just start, please. We have not too many people, so that's okay. So, but please start with posting a question in the chat. And again, keep in mind, this is being recorded and this will be excerpted and put onto the internet because this is what lawyers do now in this marketing environment, right? So with that in mind, please feel free to pose a question. And if the group dynamic is sufficiently small and sort of malleable, then we can maybe get into a bit more detail about this, right? So I'll wait in the meantime for any question to be posed in the chat. And one thing to keep in mind in terms of recent events, yesterday, the 18th of September, there was an announcement which is of particular interest to people who are seeking work permits, or sorry, rather study permits, and then possibly work permits to Canada, where essentially there is a language level requirement imposed for people who are studying at graduate level. I believe you have to have a Canada language benchmark of 7 plus proof of graduation. And I believe it may be lower, maybe 5 for undergraduate. So that would be a precondition to getting a work permit, what's known as a post-graduation work permit. And if you know anything about express entry, post-graduation work permit is an essential component for permanent residency under the Canada Experience class, because you need 1 year of Canadian work experience on a valid work permit. And the combination of the required amount of points now in 2024, and even arguably even since perhaps July 2022, is such that, practically speaking, you need fluency in English and 2 years of work experience. And nowadays, since arguably, I believe, May of 2023, you need targeted work experience. And you could sort of see these kinds of sentiments all over the internet, which is the reaction to the formerly somewhat more straightforward pathway. So it was a straightforward pathway before. With that in mind, please keep the question or questions coming. I will read the first question, which relates to finding information on the Refugee Resettlement Program in Canada and as a pathway for immigration. So with this program, Refugee Resettlement, this is typically associated with people who are outside of Canada, and they are often either recognized or confirmed to be recognized by the United Nations High Commissioner for Refugees as a refugee, or in some cases, in the alternative, they are, in a de facto sense, recognized by the country they are in, which is not their country of residence, but their country from where they fled persecution. They are recognized in the host country as a de facto refugee by virtue of the fact that they do not have what is called a durable solution. They have difficulties being able to work. Their status in the host country from where they had to settle because they fled their home country is such that they don't really have a long-term solution there. And those are those sets of two statuses are the typical profile for somebody who may get settled under Canada's overseas refugee program. If we delve into that a little bit further, because we have some time, not too many questions, but so what happens is there has to be a kind of sponsor for that. So the types of sponsors can be what's known as a group of five, which are Canadians who form a corporation and form a trust account with a sufficient amount of settlement funds and say, we shall be responsible for the first 1 year of this family who intends to be resettled in Canada. So you need a group of five is another essential component, not just the UN recognized refugee status. Or similarly, if you do not have a group of five to support your resettlement in Canada, you may be the beneficiary of a sponsorship agreement holder, which is a category of organizations, usually religious institutions like churches and masjids and temples and things of that nature, which are registered with the Canadian Immigration Department, and they have the authority to support a sponsorship of a family or an individual who are recognized by the United Nations High Commission or recognized by the host country from where they are currently residing to avoid persecution as refugees. That's not the end of it. I've only talked about the basic components. So the other elements are that there is still a screening, which is why these cases tend to take a long, long time. Because periodically there is a scandal where out of the hundreds of thousands of people who do come to Canada under any category, one of them may have committed something which can be akin to what we call inadmissibilities. Some inadmissibilities may be something generic like criminal or misrepresentation. And the other more dramatic types of inadmissibilities are advocating human rights violations or advocating the overthrow of a government. And refugees sometimes get more scrutiny in these types of latter dramatic scenarios because they are often opposed to the interests of the government from whence they fled. And in some cases, they may have held a high up position in that government, and then that could lead to the concern that they themselves were a party to any human rights violations connected to the government from where they fled, in the event that they were, for example, a high-ranking official in the government. So this leads to the delays in resettlement of refugees in Canada. But if you get through the screening, then there is an interview you have to go through because they want to corroborate the events that led you to flee your country of persecution. The delay is compounded by this requirement for an interview by a Canadian immigration officer. So, in a sense, it's the only game in town if you're fortunate enough to have the support of a sponsorship agreement holder or a group of 5. So that's kind of an overview. I'm just going to continue. You can always pose a follow-up question to that because that's a very broad overview. But I just want to continue with the questions that I see. So one is related to work permits, specifically post-graduation work permit. And it says, it poses the question as follows: is there a 2-year extension for PGWP holders, which expires in 2024? So this question is essentially asking whether or not there is a policy, usually a temporary policy, which we have associated with COVID 2 years ago, to allow, in a sense, a sort of blanket extension for PGWP holders. Given the fact, I suppose, based on my reading of the news, that a lot of the PGWP holders no longer have a viable pathway for permanent residency, despite accruing 2 years or maybe even 3 years of work experience in Canada, because they chose a course of study which is not STEM, which is not, i.e., science, technology, engineering, or mathematics, or healthcare. And so this has left people who have studied, for example, just finance or administration to not have a pathway for permanent residency because of the phenomenon of targeted draws. They do have general CEC draws, but the reality is that the minimum point threshold exceeds 500 points. So practically speaking, what that means in terms of a rough profile is that you have a master's and 2 years of work experience in Canada. You're fluent in English. You have education. The master's is in Canada. You may have a sibling in Canada. And that's the very narrow parameters of a generally successful Canada experience candidate who's not working in STEM or healthcare. And so that has led to rumors and protests, if I recall, looking at various news media about the effective, the sort of metaphorical pulling the rug out from these candidates who may have toiled a great deal to accumulate the funds to study in Canada and work in Canada. And that was the rationale for some rumors to be expressed that there could be some additional time allocated to the normal PGWP duration. The normal duration is connected to your duration of the Canadian course of study you graduated in. So namely, if you studied for a minimum of 2 years in Canada and graduated, then you'd be entitled to a 3-year work permit, assuming you graduated from a publicly funded college or university. So in summary, after this context, essentially, there is no policy-based method to extend your PGWP. There may be discretionary pathways to do so, and you can pose that perhaps in the chat if we have time after I go through these. And that may be, in some somewhat rare circumstances, that may be another pathway to preserve your ability to work in Canada in the hope that you could accumulate work experience in Canada. If not, you may have to leave Canada unless you pursue a discretionary pathway for a work permit. And try to pursue immigration by improving your chances for your profile as presented to Canada Immigration while being outside of Canada, preferably not getting too old in the process, which would have the reverse effect of reducing your chance of success for immigration to Canada as a skilled worker. So with that in mind, right, I see another question related to visitor visas to Canada. So just kind of digest it while I read it out loud. So I'm inquiring about the possibility of obtaining a visit visa to Canada, accompanied by my mother and younger sister. Our sponsor, my uncle, is a Canadian citizen who previously sponsored my aunt, who is currently in Canada and pursuing humanitarian-based asylum. So in light of this previous sponsorship, I would like to know, firstly, can my uncle still sponsor us for a visit visa, given his previous sponsorship and my aunt's current asylum application? So a number of questions. Maybe I'll try to deal with that one first. So when the word sponsor is being used in the visitor visa context, I would just because lawyers get a bit anal retentive, we like to change it to like support, as opposed to sponsor, which has a very specific definition in the immigration laws, which doesn't cohere with a visitor visa. So I would change the first question to, can the Canadian uncle still support, for example, through a sworn statement, this individual and his mother and younger sister's potential visitor visa application? The short answer is yes. However, what with the increasing efficiency of artificial intelligence, the ability of Canada's immigration department to kind of look at what the immigration notes call hits, means that they might find a hit showing that the person who wants to support your visitor visa in fact supported somebody else's visitor visa. And there's a further notation that there are new notes showing the person who was supported by that visitor visa has now filed an asylum claim in Canada. So the officer in that scenario, if they do get those what are called hits in the computer, the GCMS system, Global Case Management System of notes, they could use their discretion to say, I've weighed everything, such as the purpose of the visit, the amount of funds this individual and the two accompanying dependents have. I've weighed what else? The purpose, their ties to their home country, and I've weighed the fact that they do have a Canadian uncle in Canada who wants to support them. So as long as the officer considers everything, then that uncle could support the application, but there's a chance that there is an increase of a chance that there'd be a refusal. That being said, there's some perhaps follow-up questions, right? So I may have tackled some of them during the course of my answer, but related to this potential visitor visa application is the question, are there any specific requirements or considerations? So I've kind of touched upon the typical hallmarks for a temporary resident who is not working or studying, namely ties to the home country, ability to make money in the home country, obligations in the home country, purpose of visit, their immigration history with other countries. There's a few others too that are not as common. Admissibilities in general. presence of family in Canada. Are the family in Canada close relatives or not close relatives? Because then these colloquial ideas on the officer's part, such as push factor or pull factor, namely, is a close Canadian relative going to pull you to Canada irreparably and cause you to not comply with the temporary nature of a visitor visa? Those are the factors, for example. There's looks like a related question to visitor visa applications, which is there a connection to the asylum application? So there's really the fact of an asylum application for somebody who was supported in a visitor visa is basically, at this point in time, an established fact on the ground. So it would take some creative explanation to distance you and your dependents from the fact that your relative made asylum application with the support of your relative. There's a concern that there would be amplified scrutiny in your application. And the best way to deal with these types of situations is to try to give some intelligent context in your visitor visa application, which can firmly place the role and the distinction between the person who made the asylum claim and the host who supported them in the visitor visa application. So that would take some very diligent and comprehensive written arguments. And the overall question related to this is, what are the chances of a successful visit visa application given the circumstances? So I've touched upon the general requirements. In this particular case, there's an additional hurdle which would have to be addressed, which is to convince the officer that I am not going to make a refugee claim as a visitor visa applicant, despite the fact that my relative made an application for a refugee claim with the support of this uncle. So written representations are important. Keep in mind that artificial intelligence is used for temporary applications by Canadian immigration officers to help speed up the process, and the artificial intelligence tends to not take into account some of the information you present in the visitor visa, leading to a wrongful refusal. Wrongful on the basis of failing to take into account all of the documents that were submitted in the visitor visa application. There's not a great deal you can do about that except resubmit the application or request for reconsideration of a denied visitor visa application. Or in some cases, you, depending on the stakes connected to the visitor visa application, you take the denial of the visitor visa to federal court. This does happen if there is an important purpose for visiting, like a wedding or things of that nature. So there, it looks like there's a follow-up to the overseas refugee case. So there's a situation which I suppose is extremely common, which is that the person who asked about the group of five or the overseas sponsorship has no connection to a church which has a sponsorship agreement with the Canadian government or family. And even the other fundamental problem, even the United Nations High Commission for Refugees hasn't really made out to connect with the family. And I do see this quite a lot. There's actually a queue, because there are millions of displaced people because of unstable governments. There's actually a queue for getting properly registered with the UNHCR. And without that proper registration, which requires and entails that the UNHCR does its own scrutiny of the candidate, that effectively you can't really get the application off the ground without that, unless you could get some cogent or robust documentation from the country you live in, which can constructively say that you're a refugee claimant and you do not have a pathway to permanently settle in the country you're living in, namely, do not have a durable solution in the country that you're temporarily living in to flee persecution. So unfortunately, due to the volume of displaced people, there's not a whole lot you can do, unfortunately. And it's extremely frustrating for people in that situation. But there's really not much else from a legal point of view I can mention for this. And there was a related question to the visitor visa, where it looks like the uncle had written a support letter, and then the family or the individual who used it made the refugee claim. And the question is more like a comment. It says the people or that individual, presumably the others, are from the country of Pakistan. And by definition, another fundamental factor in the chance of success for a visitor visa application is the country of origin, because every country of origin where there is a requirement for a visitor visa to Canada entails that the officer dealing with the visitor visa looks at the individual circumstances in relation to the average life and economic circumstance of the average person in Pakistan. So sometimes subconsciously in the back of the officer's mind, they tend to start to look for people who are looking or presenting themselves with a significantly higher amount of economic establishment in their home country. The proverbial 1%, if you will. And then there's a subconscious tendency just to give visitor visas to the elite of a developing country. You know, things like those types of individuals who own, large business concerns or things of that nature, to the expense of what might in Pakistani or local standards be construed as middle class. So in a sense, sometimes the middle class as defined in a particular country in and of itself does not show prominently or favorably for an officer who is thinking of granting a visitor visa to somebody in a more sort of economically challenging country like Pakistan. So that's a bit of context from country to country when dealing with these kinds of situations. And similarly, if there's political instability, and let's say if the person has a last name that indicates they're a minority, then there's an additional concern, which is that, will this person make an asylum claim because their last name seems to indicate that they're a minority from the country, and their economic ties or their job is not terribly strong. So that fact of political instability leading to potential persecution of a political or religious group could make the chance of success for a visitor visa even lower. And don't forget, officers sometimes will just Google your name, and they'll see if you were a member of a political party that's out of favor or is being persecuted. Again, that could reduce the chances of success, because they may, if they take a cursory look at your visitor visa application, they may think you're just trying to escape the country because you're on the losing side of a political battle, or you're a persecuted minority of some sort. So something to keep in mind in terms of the category of country and the relation between the country circumstance and the chance of success for a visitor visa. So another question I see here relates to labor market impact assessments, and it's posing, how do we now have to be outside of Canada to apply for such, as we are no longer able to move from visitor visa status to work permit status? So this is a reflection of a change in policy. Recently, the policy established during COVID-19, which allowed people on visitor visas who were inside of Canada to apply for a work permit while inside of Canada on a visitor visa, that was recently eviscerated because COVID is no longer affecting the economy. The reason for this policy was that people could not even board a plane and employer needs eventually did pick up during COVID. So, of necessity, they had to have this policy to allow people with visitor visas to apply for a work permit. It's no longer existing. The kind of related pathway, which is to apply for a work permit at the port of entry, particularly a land border at the US-Canada border, colloquially known as flag polling, that's been eliminated for post-graduation work permit aspirants, PGWP applicants for work permits. They can no longer do that either. Again, this is that latter elimination of the policy may more be related to the amount of work that the Canada Border Service agencies have, and they just don't want to have to deal with that at the US-Canada border for this. So then ultimately, the question is, how can you transition from visitor visa to work permit status? So if you're inside of Canada on a visitor visa, you could still apply for a work permit, but the work permit application would be disposed of most likely by an officer who is dealing with the country of origin that you hail from. So, for example, if you're from Suriname or Jamaica, then the work permit application would be dealt with by the Canadian Visa Office in Port of Spain, Trinidad, even though you're in Canada. So you could still, in theory, you could physically be here, but when it comes to the issuance of this, you may have difficulties electronically downloading the approval letter and then flag polling, because that is less and less of an occurrence in this situation. It still is generally possible if you're from a country that is exempt from the requirement for a visitor visa to apply for a work permit at the border, depending on if there's a medical requirement imposed for the job you intend to take up. So what does this practically mean, this elimination of the policy of applying for a work permit and having that work permit issued inside of Canada being eliminated? Essentially, what that means is that you may be convoked for an interview at the Canadian visa office corresponding to your passport. So if you're from India, you may get convoked for an interview at Chandigarh or New Delhi. If you're from Pakistan, I believe it's Abu Dhabi would have to deal with this. And if they convoke you for an interview, and if they don't allow an electronic interview, then you may have to leave Canada and attend that interview. So that's the practical consequence as of now, as of September 2024. So with that in mind, let me see what else. So there's an individual in the next question from Haiti devastated by armed gangs. President was assassinated. Oh yeah, there was an individual named Barbecue who was one of the top gang members, if I recall the news properly. And there's a UN mission, if I recall, sponsored with the support of Kenyan troops, if I remember the news properly, about these terrible events in Haiti, which Canada has not a good role in, but that's beside the point. So that makes it extremely difficult for refugees, because if you're an educated layperson, you'll know Haiti is probably the poorest country in the Western Hemisphere, owing to, I suppose, French colonialism and other things as well. So that just makes it all the more difficult in these kinds of situations. Anecdotally, this is just anecdotes. I know some people, they escape to the neighboring Dominican, and sometimes they can get some kind of respite there. But those are very, very few and far between, unfortunately. So there's really not a lot that can be done without the UNHCR or the, well, if it was a functioning government, the functioning government could indicate that you're a refugee. So there's another question related to whether you can handle a visit visa process from Pakistan without travel history. So The question relates to a visitor visa, and in my interpretation, the question relates to what is the chance of success for a visitor visa when the person seeking the visitor visa has never traveled outside their country. So lawyers always want to paint the best picture for a visitor visa application, but that doesn't mean ignoring the negative aspects. So a lawyer would highlight all of the positive aspects. Hopefully, there is decent establishment, decent education, decent job in the country, maybe close relative who's remaining in the country. Maybe there's like a spouse who's going to remain in the home country. And then the lawyer would devote some written arguments about the reason for the lack of travel. And if applicable, we would research any court case law that says denying a visitor visa application solely because of a lack of travel is what we call patently unreasonable and should not be done. And we would quote that in our written arguments. So those are some of the legal tactics we use for visitor visa applications. And so with that in mind, let's see what else is there in terms of the chat. Okay, so there's one related to permanent residency under the current state of affairs, which is targeted in terms of occupations, targeted occupations as a pathway for PR or permanent residency based on express entry / Canada experience class. And the question is whether pursuing a master's in mathematical finance would be considered to be under the STEM program. I would say most of the time, mathematical finance, at least, I mean, this isn't accurate, but this is just anecdotal based on what I see. But the clients I see who have a master's in highly concentrated math and or economics, they may have work that is analytical at a bank as opposed to financial. And it may be highly intense mathematical analysis at a bank as opposed to selling financial products. So if it is more on the analytical side, dealing with the data, with the petabytes of data that banks no doubt have to try to deal with to predict the economy's pathways, etc., then there's a good argument that it may be on the list of occupations that are targeted. Just as an aside, because we're on the subject of the relevance of STEM jobs to permanent residency, sometimes there are targeted draws by the provinces. So somewhat rarely for the province of Ontario, they have targeted draws for certain occupations. I recall, I believe in May 2024, there was one related to information technology. And sometimes there's healthcare. And so you may very well, as long as you specify in your express entry profile that you want to settle in a province that offers these targeted occupations based on the demand of the labor market in that province, that may increase your chance of success for permanent residency. So there's, I see a question related to the outside of Canada refugee process, which says if the person does not have a church, which is a sponsorship agreement holder, does not have a Canadian group of 5, but have a visa, can you claim asylum from inside of Canada? And what's the chance of winning such a case based on humanitarian-based asylum? So the question is basically saying if the person's inside of Canada, can an asylum claim be made? Well, definitely yes, because if you're inside of Canada, then there is an entire regime, court system, under the auspices of what's called the Immigration Refugee Board Refugee Protection Division, which would hear the claim, and they would want to know if you're a member of an identifiable group, such as a religious minority, maybe you're homosexual, or maybe a political party, or maybe the nature of your identity as expressed to the public in your country of origin is such that you are a target because of some attribute you have, such as you're an albino in Iran, for example, sometimes they're persecuted because of a fundamental trait that they possess and they cannot really hide. If you have those kinds of circumstances and you're inside of Canada, that could very well be a very strong basis for a successful refugee claim inside of Canada. So, on that matter, though, there's a sort of related question, which is the role our office has. So we can only advise on refugee matters if the person is actually in Canada, unless they're the type of person that is doing or the beneficiary of a resettlement program, because then their pathway for refugee is would be totally done from outside of Canada. So, but if it's a person who wants to make a refugee claim inside of Canada, we can only advise them or if the person's actually here, just based on some interpretations of the enforcement provisions of the Immigration Refugee Protection Act. And so that protects both us and the person by not advising them until they're at least at the airport or inside of Canada. So I'm looking if there's any further questions, because we do have some time for this. So the news in general for immigration, at least for candidates inside of Canada who had the expectation of using Canada Experience class as a pathway for permanent residency, it's largely truncated in favor of people with the types of jobs I mentioned earlier, STEM jobs, healthcare, or people with French language skills, because the government does allocate a priority for people who have French language skills and work experience in Canada. So if you have an affinity for languages and you're inside of Canada, and you had the misfortune of taking something like financial, accounting or things of that nature, which may not be targeted in the foreseeable future, you could consider French, and then that could open up some provincial nominee programs, such as Ontario and some of the maritime provinces, which offer a pathway for French speakers with Canadian work experience. So that's kind of the way it's going to go. There no doubt will be an election, I believe, in 2025. And in advance of that, what we are seeing is there is a significant amount of what we call enforcement work for people who were in Canada and have lost their status. So what enforcement work means is that the government is allocating a priority to removing people who do not have status. There was an article, I believe, in August 2025, or 2024 rather, that illustrates that they've allocated removal from Canada as a priority because the government does not want to have statistics showing that there's a lack of enforcement and a proliferation of people who do not have status in Canada during an election, because it does not look good, effectively. So that is the impetus for the increase in removals from Canada. Excuse me, just got a little itch here. So you combine that impetus for removals being executed, combined with the slower approval of immigrants as a whole, and rather the targeted draws instead. It's essentially a reflection of the fact that there were a lot of immigrants who were granted status in the past 2 years. And because of that, they want to find ways of dealing with public opinion, which immigration policy is highly sensitive to, especially when an election is approaching. So that does not really bode well for granting status, but it does seem to indicate the process of removals from Canada will be maintained, as it hasn't been increased in the past 14 months or so. So there's a question related to, are there any PR programs that require 6 months of work experience? I'm going by memory, but I believe it's Manitoba and the Atlantic provinces that have their own provincial program that says if you have 6 months of work experience in that province, then there is a pathway. However, from what I recall, either in Manitoba and or the Atlantic provinces, to take advantage of the truncated amount of work experience required, you usually have to have graduated at the college or university in that province to get the benefit of that. The presumption is that the combination of studying in the province and working in the province for 6 months, and only 6 months, is a stronger sign that you would more likely be able to and willing to remain in the province because you studied and worked there. So you made that province your de facto home. And given the demographic realities, which are disproportionately leading to too many old people in the maritime provinces, I can see why they would have that rationale. They want young, active people to contribute to the labor market in those provinces so that those provinces can do reasonably well, not just the more wealthier provinces in Canada. So that's sort of the last question I see thus far for this, right? We still have some time, at least 10 minutes or so. So in there is a phrase called the Riot Act, and reading the Riot Act. It's an aphorism or cliche, which means just know the law before you're going to do something. And that means you're free to look at the internet to get some ideas or anecdotes about similarly situated people with similar immigration circumstances as yours and consider those. And again, look at immigration fora to see if there's some information. And I'll obviously look at Canada's official immigration website to see what is there. And look at the provincial websites, which talk about their pathways for provincially based or targeted immigration, such as for occupations in demand in the province or entrepreneurs in those provinces. But you want to actually get legal advice because it does get extremely complicated. And if you're going to spend money on a government filing fee and wait, spend time waiting for the disposition, you may want to see if the foundation for what you've started in terms of a visa pathway is actually a viable one by getting advice. So looks like a question related to asylum, which is when you do make the class for the asylum, how long does it take to process and what are some benefits related to that? So this is talking about, I think, refugee claimants in Canada. So as a refugee claimant in Canada, you are entitled to apply for a work permit. However, seems to be some administrative delay in the issuance of the work permit. So anecdotally, we see delays of 6 months. The problem also is that the inside of Canada refugee system is backlogged. So you may not actually get your refugee claim decided for a year and a half at least, based on what has been issued by the Canadian government. They've streamlined the process to try to reduce the steps needed to file and have a refugee claim disposed of, leading to a decision in Canada. So that gives some sense of the time frame for the disposition, the decision on a refugee claim, and the delays in getting a work permit while awaiting the outcome of the refugee claim for this. So there's also a question, can you make an asylum claim at the airport? No, the law says you can. There was a slightly scandalous article, I believe, maybe 2 weeks ago, where apparently the Canadian agent at the border was heavily encouraging the person to make a refugee claim, and that was not their intention. Their intention was to visit their children in Canada because they were elderly people who had either what's called a super visa, which is a long-term visitor visa, or they had a visitor visa, and there was some miscommunication about whether they qualified for that visitor visa at the airport. The officer was, for whatever reason, said, oh, why don't you just make a refugee claim? So It is common, and it's embedded in the fact that Canada is a signatory to the UN Convention. So we agreed by being a signatory to have a refugee regime and process at the port of entry. The airport, I would want to emphasize that it's limited at the Canada-US land border owing to the Safe Third Country Agreement, which essentially says you cannot make a refugee claim in Canada at the land border unless you have an anchor relative in Canada, such as a close relative, not like a cousin or something of that nature. So the short answer, yes, you could make one at the claim. You don't need a lawyer necessarily. But keep in mind that you get bombarded with a ton of documents, and usually they will give you the courtesy to fill them out later, and you definitely want a lawyer to assist you with the forms, because if there's some omissions in those documents, that could completely and utterly destroy and eviscerate your chance of success for the refugee claim for that. So get advice for these more complex matters. So I see another freshly popped question in the chat where it says, if you do, or complete, I suppose, a master's program in Canada, can you obtain a PGWP for 2 or 3 years, regardless of the length of the master's program? So anecdotally, we sometimes try to make the case and say that this master's program in particular, the nature of the course of study is that it is equivalent to 2 years of study. When we've been successful in making that argument, then the person was able to get a 3-year PGWP despite the duration of the program only being 1 year. There may be some immigration policies that corroborate this now, because PGWPs are really creatures of policy, as opposed to like the law, as opposed to the Immigration Refugee Protection Regulations and the Immigration Refugee Protection Act. So there's a monumental slew of policies that govern the issuance of PGWPs. And if you find them on the internet, there may be a specific exemption or a specific qualifier to encourage the officer to look at the context of the 1-year course, and maybe to encourage them, if they're prompted through legal arguments, to consider issuing a 3-year duration work permit despite the course of study only being 1 year, because the 1 year under the normal situation only allows you a work permit of 1 year duration. So I hope that disposed of or gave some context to that particular question. Getting kind of close to the end, but by all means, if there's any other question, please feel free. I'll just be here awaiting any other question, because again, this webinar is held every third Thursday of the month to allow you to get some general guidance about this. There's, in some situations, the persons who attend the webinar, they've already filed something and they're just curious about, is their application going to actually go somewhere successful, or is there some need to buttress the application with some legal arguments, or maybe even the need to withdraw the application because there may be some fatal argument or document, or there may be a fatal omission in the application leading to the need to withdraw the application before inadmissibility is found or imposed by the officer, leading to, for example, a 5-year ban on the basis of a material misrepresentation. So an example of that is simply forgetting that you were denied a visit visa to Australia, and that fact is easily detectable by the Canadian authorities, and that omission could lead to a 5-year ban from Canada. So you may want to withdraw the application, redo it, things of that nature. So again, I started a bit late, so as a courtesy, I can stay a couple of minutes for this, right? For example, I'll take another peek there. But the pathways, generally speaking, they're going to be quite challenging, and compounded with the fact of the increase in enforcement work, which is administered by the Canada Border Service Agency. This means that people who, for example, have been in Canada either as people who did not get PR through Canada Experience class, or people who maybe they started the process for refugee but did not get proper legal advice, and then their refugee claim was failed, and maybe their appeal at the Refugee Appeal Division was unsuccessful, and maybe their subsequent federal court case was unsuccessful, and maybe their pre-removal risk assessment was unsuccessful, leading them to no more impediments to removal. Sometimes requires you to consider going to federal court to stop removal. So that's another, we can have a whole webinar on stopping removal related to the concept of stays or pauses of removal, this kind of thing. So I hope that provided some general guidance and things of that nature. My name is Max Chaudhary, and the website for our law firm is www.chaudharylaw.com. It's a law firm with me and 2 other lawyers and some administrative staff. And we do take the more complex cases as a law firm headed by somebody with over 30 years experience. And if you're in a situation where you're not sure about an application you're about to file, or you've already filed something, or maybe you received a refusal, you can reach out to us at www.chaudharylaw.com. So enjoy the rest of your evening. Have a good one. Thanks. Bye-bye.